And if you just want to introduce yourself and then please continue. So Bhante, thank you very much for taking part in the symposium. And if you just want to introduce yourself and then please continue with your presentation.
Yeah, thank you, Mediator Vikram, first for giving me this wonderful opportunity. And I think it's the first time I'm speaking in an international forum of this kind on mediation. Now, coming to speak about myself, I'm an academic and a teacher in the university, and I've been trying to promote mediation in the education sector in the last few years. I'm also one of the first who has trained in the Singapore Mediation Center, and I'm also on the panel of CIMI. So that's about myself. I'm also a trained counselor, and I've been working in a bank, a nationalized bank in India for almost 20 years. So the topic for today is mediation seen in India in the era of Singapore Convention on Mediation. In the last couple of years, there is a lot much more of awareness about mediation and curiosity as well in India. That is compared to before. This is possibly because of the signing of the Singapore Convention on Mediation, in which India was one of the signatories. Now, this convention, just let's go through it briefly. This is a convention that has given recognition and acceptance to mediation as a method for resolving problems after the Pound Conference, wherein Professor Sanders introduced this concept. Now, the purview of this convention is restricted to cross-border disputes. Then why is it that we are giving so much of importance to this convention? This is because many of us countries are expecting that just like the Singapore Convention on Mediation, which has paved way for mediation for dispute resolving in cross-border disputes. Similarly, it is expected and hoped that mediation will be an accepted form even within the country on the domestic scene. So the format for today will be a few initiatives, many in fact, that have been taken in the last couple of years in India. Then we'll have a brief overview of what the Singapore Convention has offered. After that, we'll see if any of these features can be integrated into the Mediation Act, for which the Supreme Court Committee on Mediation was put in place by the Indian government and the Supreme Court of India in order to facilitate the putting in place of the Mediation Act and its enforcement. Now, it's not as if all of us do not know about the Singapore Convention. Still, just let's go through a few important features, the salient features that stand out in this convention. We also had other conventions before this, like for instance, we had the New York Convention, which gave recognition to arbitration as an ADR method. And then we had the Amphitryon, which brought about harmonization and unification. In this way, a voice was given to the developing countries so that their voice was heard. Then rules were also formed and implemented. After this, the Singapore Convention was put in place. The important contribution is through the Singapore Convention is the introduction of a new instrument, a legal instrument, that is the International Mediated Settlement Agreement with unparalleled power. So this ensures expedited enforcement, something that is not possible in any other form of dispute resolution. So this is one of the outstanding features of this Singapore Convention, what it has contributed in the field of ADR. Now, we've already stated that the scope is cross-border disputes. It doesn't cover family or household disputes, inheritance, or employment law. Now, this is a brief statement of what international and cross-border covers. International can be any two parties that have reached a settlement agreement, and these countries can be in two separate states, or in case they are in the same state. Even then, it can be considered an international settlement agreement if the business is being conducted in another state. Another important clause of statute is it's not required that the place in which enforcement is to be conducted should be in the place where the agreement has been concluded. So all these people, whoever is involved in a cross-border dispute, they can be the users, like sole proprietors, MNCs, corporations, anyone who is involved in a cross-border dispute can be using this convention. Now, other thing is the settlement agreements which have been covered as arbitral award or concluded during proceedings of a court, they are not covered under the Singapore Convention on Mediation. Now, here are a few distinguishing features of the SEM. Please keep in mind that this convention was put in place much before the COVID started in March of 2020, and when online dispute resolution became a norm once the COVID started. This convention and treaty was signed in August of 2019, and it conceived of many clauses and statutes which facilitated online dispute resolution. And then, as in the other cases of mediation, there's a lot more flexibility that is involved, and whatever be the gateway in which the parties enter into mediation, there is no restriction. Another important contribution or statute of the Singapore Convention is that it has delocalized mediation. Just a moment, 1 minute.
You want any comment up till now?
So it was good. The topic is interesting. So it's okay.
Yeah, I'm sorry for the sound coming from my end. Yeah. Another important statute is the delocalization of mediation, which is the basic tenet of mediation. That is, the mediation process can be done at any time and any place. Now, again, this was conceived at a time when online dispute resolution was not the norm. So that is a significant contribution of the SCM. So it has made the dispute resolution process that much more easy because of these two statutes and clauses. Now, for this settlement agreement to be implemented, it can also be in writing and online. Now, in writing clause in the SCM includes any form of electronic communication also. Something like this was not covered in other forms of dispute resolution, for instance, in arbitration. Now, this electronic means of communication included SMS texts or emails and so on. Whatever be the information that can be recorded through electronic means, and if it can be retrieved at a future point in time or whenever required, it comes under the purview of in writing under the SCM. So this again was a very important contribution. The mediation process, it is not required to be concluded in one go in a single document, and it could be ad hoc, and mediums like Skype and Zoom, internet, all of these, AnyDesk, they were also allowed in the process of electronic communication. Another contribution was the institutionalization of the mediation platforms. Now, these platforms allow for the back and forth between the two disputing parties and the mediators to be done then and there without waiting for responses, as in the case of emails, SMS texts, and so on. So the documents could be changed, altered, or corrected then and there, and each platform had its own set of rules. Sometimes mediators could be in-house or from outside. Now, as to the enforceability of the settlement agreement, which I have stated is one of the most important contributions of the SCM, the signatory countries went to the extent of changing the laws on recognition and enforcement of the outcomes, and they were expected to expand the number and nature of legal instruments and to modify their own laws and rules of civil or court procedure. So this is a Himalayan, or in the context Himalayan, in the Indian context Himalayan, we can say it is a Herculean contribution. So if a country is changing, signatory country is modifying its own laws and rules of civil or court procedure in order to honor the terms of the SCM, this is indeed a major and very big contribution. Now, another aspect is that what are the rights or privileges too that the parties to the dispute have in the context of international mediated settlement agreement. Now the two parties can use the settlement agreement like a sword against a sword. They can attach the assets or property of the dishonoring party to the extent that dishonor has occurred. Now, this single statute gives immense power to the Singapore Convention in that there is a kind of assurance and predictability and certainty that the settlement agreement will be taken forward by the two parties. Such a provision is non-existent in any other form of dispute resolution. Now, the mediation is flexible. This is, of course, one of the tenets of mediation, whether the SCM is introduced or not introduced. Now, in the case of, just let's go through it briefly. Mediation allows for discussion on the mediation platform. Any issues, even not related to the dispute, or if the issues have not in any way triggered or started the dispute. Any issue which is of importance or interest to the parties can be discussed on the mediation table, whether it impacts the resolution process directly or indirectly. Like for instance, here there is this person, this young lady, who's having a business. She's a florist, and she has business dealings with this person over here. And then there has been a dispute with this brother in the last 6-8 months. This is because she runs a florist business in a place staying where they shared the accommodation with their father. And after the death of the father, the brother says, I have a share in the business profits and so on. So here, there can be a number of undertones or layers to the dispute. It's not only about the money. It's possible that there are more emotional undertones in this dispute because it's the case of two warring siblings. So the dispute can be expanded. The settlement agreement can be expanded much beyond the purview of settlement agreement that is possible in other forms of dispute resolution. Now, as per the Singapore Convention, there is no restriction on pathways to entry. It can be through court information sessions or mandatory and voluntary referrals by courts and referrals by other competent authorities. And also, in order to encourage mediation, cost sanctions can also be put in place, and there are also can be legislation. Now coming to delocalization, which was the punch of mediation in that it was not required that the process be localized to a particular place. The place where the enforcement could be carried out could be different from the place where the settlement agreement was concluded or put in place. Also, the rules and laws of domestic mediation can or cannot be applied for the signatory countries. and designing of the solutions is not restricted and specified to a particular legal system. Now coming to the post-COVID scenario, with online dispute resolution, which has become the norm, the punch of delocalization has reduced. However, even now, the difference that is accepted between the place where the settlement agreement is concluded and where it can be enforced, acceptability of this particular statute makes this convention important. Now, coming to the challenges of putting in place and implementing the Mediation Act in India. What are the issues in the terms of the Singapore Convention, which can be challenges or obstacles in taking the mediation process of mediation forward in the domestic scene? Let's go through each of the features that I have spoken about. First is the online mediation, and one minute. Yeah. So these are the challenges of putting mediation online in India. In that, there's not much awareness amongst parties, and encouragement and permission by the courts may be possible, may not be possible. And also in the courts, the awareness of scope of the Singapore Convention may be there or may not be there. And also there is a requirement for putting in place more platforms for conducting the online mediations. And in one of the talks, what I came across was there was a course on integrating tech with online support and mediation, conduct of mediation. So these are some of the problems that could be faced in case of online mediation if it is conducted in India. Now coming to enforcement, feasibility of implementing the settlement agreement in writing. As a country, if the disputes are major and business related and institutional or organizational, there is a possibility that the implementation of settlement agreements in writing is possible, and it can also be made, mediation can also be made mandatory. However, as a country, the enforcement of a mediation settlement, wherein a settlement agreement is put in place in writing, may not work out in a country like India. There's no guarantee or assurance that the disputing parties will honor this settlement agreement. And as to the flexibility, this is because of a cultural perspective, wherein the families are important, our culture is important, and how do you follow up on the enforcement of the settlement agreement at personal level. So these are some of the challenges in case the features of the Singapore Convention are integrated into the Mediation Act. Now, coming to the flexibility area, that is also a provision in the Singapore Convention. This is a very acceptable and attractive feature which can be integrated in the Mediation Act in India. For this again, the areas of expertise and required qualification and experience in human relations related subjects and basic knowledge of how mediation is to be conducted, and sometimes where required qualifications and experience in law. Any of these, a combination of these, would assist in the flexibility in the approach towards mediation and how the dispute resolution is taken forward. So this also covers areas like improvement in communication, addressing of emotional undertones or the true reason of the conflict, which can be possible through expertise and qualifications and experience in human relations related areas. Coming to the gateways, we have seen that there are a number of accepted gateways to mediation as per the Singapore Convention. It could be through court sessions or mandatory reference either by courts or through other referring agencies or through legislations and post sanctions. Here again, this is of course my very personal view. This gateways to mediation can be an accepted method, the gateways that I have mentioned, in case of disputes wherein institutions or organizations are into the dispute. At a personal or individual level, I do not see that mandatory mediation or these cost sanctions will encourage the parties to get into mediation. The reason for this is, in the Indian context presently, mediation is mostly court annexed. And for a disputing party to understand and know about the subtleties of the difference between various methods of dispute resolution, like for instance, between arbitration or mediation, any of these, the parties may not be very much in favor of getting into court or outside, be it just to know about mediation. And it also happens that in most cases, laws are framed in such a way in India that it is the judiciary that gets to be certified as mediators, and conduct of trainings is again for the legal professionals. So people would like to settle their own disputes at their level without running to courts, which is one of the, I was conducting an awareness program for teachers and people across the road. And when I stated that this program is for resolving of problems and disputes, the first thing that was stated was that they do not want to come to such a program. I had to make it attractive to tell them that mediation as a method can be used across the table, even at grassroots level, for solving simple family problems or landlord dispute problems or neighborhood issues or even insurance based, or in case they are going on a tour in a package tour, and if the tour terms of the tour are not honored, then a settlement is possible through the process of mediation. Now, in all these cases that I have stated, there is no written agreement, settlement agreement involved. It's more the case of the people involved understanding the reasons or issues that are involved in the process of, in the course of the fight or the dispute, and their desire to resolve the dispute. So this is the punch and the most important feature that we need to take across to people. Once we say there is a settlement agreement that is to be signed, and people have to adhere to the settlement agreement, in the Indian context, at individual level, the man on the road will not be attracted to the provisions of the Mediation Act. Even otherwise, we have our own forms of community mediation. Like for instance, we already have the Panchayat Raj system, wherein the wise elders or community leaders, they provide advice to the people. This is an accepted form of self-government in India. And we also have the Lok Adalat system. So then the issue comes up, when we are having these two, the Panchayat Raj and Lok Adalat, why do we need a new form of dispute resolution? So it needs that much more of convincing people and taking people along. Now coming to the last salient feature that I had spoken about in the Singapore Convention, the delocalization. Now, in the context of India, given the state-center tussle, again, there has to be a clear policy on the SCM provides for the settlement to take in one state and enforcement can be done in another state. So, is this provision valid and acceptable in such a way that the settlement be concluded in one state within the country and enforcement is possible in another country? Settlement is concluded in one state and enforcement in another state or across the country. And is there a possibility of the center and state tussle in the enforcement and implementation of the Mediation Act and the settlement agreements? And also, within the states, there is a possibility of a tussle. Therefore, at the point of integrating the feature of delocalization in our Mediation Act, a lot of thought has to be put in this particular perspective or clause of mediation. Other than this, in India, we have so many languages. And also, how is it that we are going to communicate as mediators? So, other than just the training in mediation, we will have to get across to people, first at the level of training, and second at the level of communicating with the people. It's sometimes not possible for mediators to be knowing that language, and then we would require translators, interpreters, and so on. Then again, the translators, there could be a possibility of miscommunication between the amongst the translators, interpreters, and so on. Of course, this is not expected, but then, it makes the dispute resolution process that much more difficult if you formalize it. That's the reason we need to have mediators at grassroots level, or those who are within the reach of access of people. The major disputes, it's okay to have in different languages. In most of the cases, the major disputes are put in place in English, in which most of the mediators are trained. Then, in this context, I would like to share that there was a case wherein a World Bank mediator who was working as an ombudsman in the World Bank, he had to manage communication with the help of so many different families, so many cultures, families, with the help of translators and interpreters, which made the process of mediation indeed not very easy. This was, I'd not like to mention the place or whatever in confidence. Next is the difference in cultures. Like, for instance, mediation as a process was introduced in the United States, and it has become an integral part of, I assume, it has become an integral part of their problem-solving method because of the way in which they are functioning. Like, for instance, I hear Susan Guthrie, I think, she conducts periodically podcasts on divorce-related issues. And we also have child custody battles, stay arrangement battles, disputes going on over there. And then we also have in certain countries in the world, let's say in the US or Canada, if the dog is barking or across the fence, then there is a case on mediation. Now, in our culture in India, most of these cases are solved within the house or within the community. If not by the Panchayat Raj, we need to equip the people at the grassroots level or the servicing community leaders to assist people in resolving the problems without going to a formal method of dispute resolution involving a settlement agreement. Also, the way our society functions is, it's not very much rule-based. Like, for instance, let me give you a very basic example. Like, for instance, in the United States, the driving test was giving a written test. I think this is on the computer, and then going through the test and knowing the rules on hand. Whereas here, it's more hands-on. And if the rules are not followed, then a case is immediately lodged. In India, it's more hands-on, and a settlement agreement, a possibility of a written settlement agreement being enforced in the context of India may or may not be possible. Now, the other thing is, the lack or less of awareness amongst the users, the public. Agreed, we are going to put the Mediation Act in place, We are going to have more mediators and more people trained in mediation. We are going to equip our students, the citizens of tomorrow, in mediation. But what about the users? Without the users being aware of this method, it is a kind of stifling scenario for the profession of mediation and for mediators. It has to be psychic in that the services of the mediators be used by the users. For this, they need to be aware, and within their access, it has to be a convenient form of resolving their small everyday life problems. This is imperative and extremely important in the Indian context. Now, the next is the approach to mediation. There is no clarity, and different models of mediation, I expect or think, are being used by different mediators. At the point when a common policy is being put in place, there has to be clarity on what is the model that we are going to take forward. Now, the next part is the job or job openings or opportunities. Here are a few tussles that are possible. First is the mediators with law qualifications and mediators without the law qualifications. Then we have mediators with human relations subjects and experience, and mediators without the human relations subjects related qualifications and experience. Similarly, a tussle between mediators with work experience and mediators without work experience. Then there is a possibility of mediators in different languages. Again, in geometric proportions, the problems involved with translators and interpreters. And all of these in combination, we have to give a lot of thought to all these areas at the point of putting in place a policy for mediation and in the Mediation Act. This is given that we are giving so much of encouragement to the citizens of tomorrow, the students, to take up mediation. Like for instance, the Bar Council of India last year, it has made the study of mediation mandatory in India. A new course on conflict resolution and mediation was introduced for the first time last year in India. We have no less than the Chief Justice of India signing an MOU that with the Singapore and speaking of mission launch. And then we also having agencies or offices, like for instance, the Hyderabad Arbitration Center. We also have the virtual summer school. And then there's so much of discussion, but everything is within the ambit of mediators. The panel discussions happen within the ambit of mediators. For instance, we have the Tamil Nadu mediation community leaders interviews. Then we have the Madhyam, which is another medium wherein there are discussions on issues relating to mediation. And here again, we have the Mediator Vikram YouTube channel. Now, all of these is fine. We're taking mediation to the students. And when you're promising them something a few years from now, it is important to keep in mind how is it that they will be able to put their learning or experience that they have gained in the course of education into practice. So this requires some amount of forethought and thinking about the future of mediation. In this context, I go around and telling students and advocating mediation, but this comes from my heart. Then there is also the case of no recognition of fee or payment for mediators or people who already know mediation without having the certification and at grassroots level. Now this again touches on the economy or generating of funds. Then again, other areas or challenges are the rural, semi-urban, urban divide in creating awareness. We still have the Panchayat Raj and Lok Adalats quite accepted even today in the context of rural dispute resolution. A Panchayat Raj president, even today, is a very much coveted post in the rural areas. In this context, it is good to take the awareness of mediation to the rural scenario, but it will need a lot of convincing on the part of the policymakers, government, and so on to use this beautiful method. Now, as to the urban context, we do not have many Panchayat Raj systems, and people, by the time we have come to the urban scenario, we want this aspect of confidentiality and taking the mediation process forward and deciding our own solutions. These are the two very important aspects of mediation. As urban dwellers, these two features are extremely attractive to most of us people living in the urban scenario. Maybe that is why in a few countries, like for instance, I was going through a talk session in which there was talk about mediation centers being established in particular soil. Yeah. In various district areas, and people coming to these mediation centers to resolve these disputes or problems. Maybe we need to have a norm, something like that, to be put in place within India. And I've already spoken about, acceptance of mediation and need for education of the social workers and the legal professionals in the Lok Adalat. As for a Lok Adalat form of mediation, which is an accepted form of mediation in India, accepted form of self-government in India, we have social workers assisting the legal professionals in the resolution of disputes. Maybe it's required to and possible to equip the social workers with training and knowledge in mediation in order to have better functioning and reach of the Lok Adalats. This is just one of the ideas that came to my mind. Now, the last is about the framework for implementation of mediation in India. As already stated, the written settlement agreement and going through the process of a structured mediation in the ambit of courts may not be very attractive to most people in India even today. Unless the issue is so big, people do not want to go to court. People do not want to go around the legal professionals for this. So it is maybe a good idea of thinking of assessment, conceiving of assessment and training programs for senior functionaries so that this could be used in the phase of in the conclusion and settlement of institutional and organizational disputes. Then we could have a second layer with simple awareness diploma program, like for instance, in case association president of a housing complex, he wants to know how to resolve the problem of the various residents in the apartment complex, then he knows how to go about it without having the assessment training or the training to be a mediator. This is also because in the context of India, we still have this respect for elders and wise men, all these things. Our culture still allows for that the headman in the family even today get that much more of extra leverage. So an assessment program and it also involves that much more of expenditure and expenditure both of money, time, effort, which many people may not be having or they may not be willing to invest. So these are some of the areas. And then basic awareness programs, even for women in the house, how to resolve the house issues. In case there's a tussle between, a student is handling issues in the class, they're having fights in the class. Instead of just saying, yeah, leave it. Well, if the teacher is equipped or aware of this process, she can assist and teach the students how to resolve the small everyday life problems like a pencil box that is stolen by one student from another student or inability to reschedule their classes. All these are small everyday problems that do not require a settlement agreement in writing or following it. So maybe a three-tier system may be a good idea. So yeah, now integrating SCM into Mediation Act. The problems associated with online have already spoken about, and relevance of the Singapore Convention. Yeah, Mediator Vikram, just 5 to 10 minutes. Can I speak?
No, as much as you want. Totally your situation get there.
Yeah. Now, the relevance of the Singapore Convention on Mediation in the dispute scene in India. The tenets of the SCM can be integrated in mediation by and for institutions and organizations in almost all formalized structures. Like for instance, in banking, insurance, tourism, hospitality, medical, police, tax officials at senior levels, lawyers, particularly senior lawyers, human resource professionals at senior levels with deciding power, and heads of institutions and organizations. That is, wherever cross-border interface is there or possible, and also when you're integrating some of these features, then wherever there is a scope for using mediation, even within the country. Then the features of the Singapore Convention that are attractive and usable in the purview of Mediation Act. These can be included when mediation is being used by institutions and organizations. This is the way forward to encourage mediation in the context of India and in ensuring that the written settlement agreement be enforced, which is a very important clause in the SCM, in ensuring the enforcement of written settlement agreements in the context of India. We can take it to institutions and organizations. Now, for this, what is the way forward? It is suggested that we have a mediation body headed by a chairman reporting to, these are all my personal ideas, mediation body headed by chairman reporting to the Chief Justice of India. Then a common mediation policy be put in place with a working group. We also have a 5-year mediation plan. We also have opening up of mediation centers and institutionalized mediation platforms, and then putting in place the rules and norms. And not less important is the publicity aspect, taking all these initiatives to the press, TV, and social media, podcasts, and even at rural level and semi-urban level. We have even today street plays, theater workshops, and burakathas. I worked in a village scenario, and through experience, I tell you that despite the TV and social media entering the village scenario, even today, the children play on the road, and means like the street plays, theater workshops, they go a long way in propagating a new idea, and these can be used in the mediation movement to spread mediation, the awareness of mediation in India. Secondly, the information about pro bono services to be publicized. Then memorandum of understandings could be signed with public institutions and organizations, like for instance, banks, MSME, insurance, hospitality, tourism, education, UPSC and UGC, municipalities, corporations, industrial zones, and so on. Now, once a memorandum of understanding is signed at that level, automatically there is an effort to spread the mediation as a dispute resolution method. It kind of percolates down. Effort is taken at the highest level. Now again, it's a question of funding of these initiatives. There is scope for tie-ups and collaborations, memorandum of understandings with Rotary, Alliance, Red Cross, and we also have a certain percentage that is to be invested in corporate social responsibility in wing of business as per, I think, some act, the CSR. I'm not aware of which act it is, but a certain percentage of the business earnings are to be invested in corporate social responsibility in India. So all of these, the CSR initiative could be used in setting up and of mediation centers and training centers, spread of mediation, and all of the activities wherein mediation can be taken forward. Also, in the case of Consumer Act forums, when the Consumer Act is put in place, assistance can be provided, and also international presence and cooperation. Now, as to the mediators, we can have an association of mediators and continued membership, continual professional development, networking, annual conferences, periodic meetings at regional levels, and can we have international festival? Maybe. And another very important requirement is for a website in public space on pool of mediators, giving their area of specialization and their contact. This again needs to be given wide publicity. This again opens up opportunities for many mediators. Then, as to the support services, opening up of spaces, personnel and facilities in all courts, Panchayat Raj and Lok Adalat for mediation. And to encourage mediation, we could also have court information sessions, mandatory and voluntary referral, and cost sanctions for people who are already going to court or willing to go to court in the case of major disputes or when institutions are involved or whatever it is, if there is willingness to go to court. And also, jobs would come up for translators, specialized translators and interpreters and support staff. Like for instance, I had stated about a one-year training program for tech support in the case of mediation process. So once a student or someone does a course of that kind, there is more scope and chance that he will be getting an opportunity to be recruited as a support staff in the mediation process in the case of, let us say, online mediations or in mediation platforms and so on. And also there is a requirement of ethics committee, given that issues of confidentiality are very much important in the purview of mediation. We need to have ombudsman and a newsletter within the ambit of mediators. Now coming to what can be done in the field of education, we could have short courses, a 10 to 12-hour course, a certificate course on awareness, which is certified by the University Grants Commission. Many heads of institutions have expressed a need for a method like mediation to be taken to the students. However, they are not able to get enrollment to these courses because these courses do not have the University Grants Commission in India, which is a statutory body in India for the recognition and validation of courses. Now, once we have this kind of University Grants Commission validation, we are already having the STAR scheme, which is already being put in place in undergraduate level, wherein students are being skilled and trained for jobs. And if they are also trained in mediation in the STAR scheme, it will go a long way. And other than this, Girl Guides, Boy Scouts, school and college teachers, and Panchayat Raj Lok Adalat social workers could be going through this program. This has to be subsidized and, if possible, made online. Then a free 12-hour online course for everyone. Like for instance, doctors, engineers, teachers, any user who wants to know about mediation. Like for instance, I had stated about the dispute within the fight amongst neighbors, fight within the community, I mean the residents in an apartment complex, wherein the president of the society has to resolve the problem. So such people, or for instance, in the case of Pakistan, whoever is interested in knowing about this, a free online course is recommended, and an introductory course on mediation and the SCM to be made mandatory in all business schools and schools of foreign business, and crafting of guidelines in assessment courses requiring basic human relations related subjects along with law and experience. Consumer forums, the guidelines can be set by the working committee. Then as to taking it to the children, there is a collaboration possible with the United Nations International Children's Education Fund. Then there is possibility of simulated mediation body, mediation parliament, inter-university competitions in mediation within India. These days we have many competitions on mediation across universities, but we don't have any inter-university competition in mediation as on date. Something like we have the MOOC competitions could be introduced, and best video in mediation, best talk in mediation, best mediator, best case in mediation, and outstanding mediator. These are all avenues in which to encourage students. Now, other than this, sponsorship and collaboration by business and outside bodies gives both funding and publicity and better participation by all. For this, encourage collaboration with international bodies promoting mediation education. For instance, we have the International Alternate Dispute Resolution Academy, the INADR, which promotes mediation education across the world. This institution, organization, had collaborated with our National Law School in Bhopal in the conduct of mediation competition last year. So more such initiatives need to be put in place and encouraged. And then we also have the peace consulting in Singapore, wherein the mediation for resolving small everyday problems is encouraged amongst the high school students. So this is all about my thinking process